So a lot of veterans come to my office and ask, am I eligible for TDIU or should I have gotten TDIU? And I have to say TDIU is one of the most misunderstood benefits the VA can issue. And quite frankly, I'm not even sure the VA understands it all the time. So what does it stand for? It's total disability based on individual unemployability. What this means is that the VA will pay you at 100% even if you're not rated at 100% because your service-connected disability renders you unable to work. Said another way, even if you're not at 100%, the VA will give you 100% money because whatever your disabilities are preventing you from working. TDIU can be decided two different ways. The first is what's called a scheduler TDI rating. So anytime you have a disability rating of 70% or higher, with a single disability rated at 40% or higher, or you have a single disability rated at 60% or higher, they should be considering you for TDIU if there's evidence in the file that you can't work because of that disability. Now, if there's evidence that you can't work, but you have a bunch of other disabilities that don't quite reach that 70% or 60% threshold, the VA can refer it to the Director of Compensation and Pension Services on an extra scheduler basis. That's very rare though. Now, what does it mean that you're unable to work? Well, the VA defines this as unable to maintain substantially gainful employment. Importantly, this does not mean that you are completely unemployed. Substantially gainful employment basically means poverty wages or more. So if you're making more than about $13,000 a year, that may be considered substantially gainful employment. Now, the caveat to that is sheltered or protected employment. Now, this gets really tricky because even the VA hasn't defined this. The courts have said, hey, VA, you need to define what this means, and the VA says, we know when we see it. But a simple scenario is where a veteran has a job, but the employer has done so much to accommodate this person that they go above and beyond the normal reasonable accommodations that may be required of a handicapped person. An example of this might be someone goes to join the family business because they can't get hired anywhere else. Now, one of the biggest misconceptions out there is that you have to specially apply for TDIU and that there's some special form you have to file or else the VA is not going to consider it. That's not true. You can preemptively send one in, this VA Form 21.8940 that documents your work history, but you don't have to. Now, what should happen is that the VA goes through your file, sees what your ratings are, and sends the VA Form 21.8940 out to the veteran to complete and send back. Sometimes they don't do this. They're either looking through the file and they don't see it, or they just fail to send out this form. Either way, the TDIU is not a claim by itself. It gets raised by the evidence that's in the file, and that evidence is, have you told somebody that you can't work, and is that associated with your claims file? But in either way, if you're applying for TDIU or you think you might be eligible for TDIU, it doesn't hurt to go ahead and file that 21.8940, even if the VA doesn't ask for it first. It may also help to write a statement in support of the claim about how your disability, again, this service-connected disability, or the disabilities you believe are service-connected, impacts your ability to work. Now, we find TDIU claims all over the place. Sometimes we'll go through a file and realize that the VA never raised the TDIU issue and never sent out the form, but the veteran may be entitled to TDIU going back years. If you've been denied TDIU, give us a call. And until next time, stay tuned for more tips on how to apply for VA disability and the VA disability process. Thanks.